I'm the head of the firm's Health Law Group, and welcome to today's program. Today, we're going to be talking about some of the key fraud and abuse laws that apply in virtually every healthcare transaction. All right. As far as some of the supplemental resources that we provided for you, there's a list there from different program guidance that the OIG has published. Those are really helpful in understanding the different fraud and abuse laws that we're going to discuss today, particularly the General Compliance Program guidance that the government just issued this past November. You can go ahead and access that at that website up there, and it's got a really good summary of each of the laws that we're going to talk about today. There's also supplemental compliance program guidance that have been issued for different types of industry segments. We'll anticipate getting further guidance from the OIG concerning those industries guidance as part of its process of updating the compliance program guidance. So watch for that as it's coming out. Just a quick caution, we're going to be focusing today on the federal laws and regulations. These aren't necessarily all of them. It's just the ones that we deal with the most frequently when it comes to these types of fraud and abuse issues. But remember that there may be others out there, particularly state laws. Each of the states may have their own laws that you have to be concerned about. I'll touch base briefly about those a little bit later on. Also, remember that the application of these laws depends upon the particular circumstances of your case, including, who the payer is. Is it a government payer? Is it a private payer or what? It could vary depending on the jurisdiction. So when it comes time to actually apply these laws, make sure that you look at to ensure that you're looking at the applicable laws that would apply in your circumstances. As we go through, you may have questions about some of the things I talk about. Because we're recording today, I'm not going to take questions during the program, but you can go ahead and submit those questions to me using the chat feature or shoot me an email afterwards, and I'd be happy to respond to them offline. All right, let's talk about the key fraud and abuse laws that we need to be concerned about. These are out there because the government is a huge payer when it comes to healthcare costs, and therefore, if they think that you acted improperly, that they want their money back. So we're going to be talking about these statutes. The first of which is the False Claims Act. The False Claims Act is the government's main recourse for obtaining money back from the government. It basically says that you cannot knowingly submit a false claim for payment to the federal government. Well, that's easy enough, right? But, none of you would intentionally go ahead and submit a false claim, but the False Claims Act can be triggered in ways that you may not anticipate. Certainly, if you're billing for services that were not provided as they were claimed, then that's a false claim. In addition, the government's taken the position that if you're submitting a claim for substandard care, that the government doesn't pay for substandard care or medically unnecessary care. So if you're submitting a claim for those, then that could be a false claim. In addition, the government stated that, hey, when you submit that claim to the government, you are asserting that you have complied with all of the conditions that are associated with submitting that claim. And if you have not complied with all of those, then you have breached that certification, and therefore you are submitting a false claim. So because of that, if you violate Stark or the anti-kickback or some of the other laws, then in addition to the penalties that can rain down upon your head under those other laws, you can get hit up with a False Claims Act case. Now, the False Claims Act not only applies to the claim that you submit, but if you submitted a false claim, you didn't know that it was false at the time, but you subsequently learn about it, then you have an affirmative obligation to report and repay any money you received improperly from the federal government within the later of 60 days of the date the cost report is due. If you fail to do that, then it turns into a false claim. Well, what are the penalties for a False Claims Act violation? Well, at the very least, you're going to have to repay the amount that the government paid you plus interest. In addition, you can get hit up with a civil penalty of about $14,000 to $28,000 per claim. So each time you submitted that, that could be an additional penalty for each claim that you submitted to the government. That's adjusted on an annual basis. In addition, you can get hit up with an administrative penalty of about $25,000 per claim. That's the current amount, but again, that's subject to our cost of living adjustment. You can get hit up with treble damages, and you can be excluded from Medicare and Medicaid, which, as we'll talk about in a little bit, is kind of the death knell if you want to practice or engage in the healthcare industry in the United States. In addition to that, you can probably also be subject to qui tam lawsuits. For those of you who aren't familiar with this, the False Claims Act allows private individuals to sue you, assert False Claims Act cases on behalf of the federal government. And if that qui tam relator, the person who pursues that, obtains a recovery or there's a settlement, then they get a portion of it. So they essentially become bounty hunters. Now, some kind of interesting news dealing with qui tam lawsuits. The Middle District of Florida, Federal Middle District of Florida, in September of this year ruled that the qui tam lawsuits are unconstitutional. We're going to have to watch how that plays out at the courts, but that it would be a seismic shift when it comes to False Claims Act litigation, at least qui tam litigations. But we don't know exactly how that's going to play out. Well, the government's actively pursuing these False Claims Act settlements. So far, from fiscal year 2023, the government reported that they recovered $2.68 billion arising out of False Claims Act situations. A good example of a False Claims Act situation that may arise when you violated another statute is the recent Community Health Network case, in which they agreed to pay $345 million. That's a lot of money to settle False Claims Act violations that arose out of the fraud and abuse statutes we're going to be talking about today. In that particular situation, the U.S. alleged that the compensation that the community had paid to its cardiologists, cardiothoracic surgeons, vascular surgeons, neurosurgeons, and others was well above fair market value, so it didn't comply with the relevant safe harbors that apply to the statutes. That the community awarded bonuses to physicians that were tied to the number of their referrals, which would violate the anti-kickback statute and Stark, and that the community submitted claims to Medicare for services that resulted from these unlawful referrals. That equals a false claim, and therefore they had to pay a whole bunch of money back to the federal government. All right, that's the False Claims Act. Let's talk about the anti-kickback statute. The anti-kickback statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services payable by a federal healthcare program unless the transaction is structured to fit within a regulatory safe harbor. Now, the anti-kickback statute is what we call an intent-based statute. You cannot knowingly and willfully offer. Now, knowingly and willfully doesn't mean that you knew that you were violating the statute. It just means that you knew that you were offering that remuneration in order to induce or reward referrals. Now, because it's an intent-based statute, it's not necessary to fit within a regulatory safe harbor. It's just if you don't fit within the safe harbor, then you're not safe, right? You could be subject to prosecution. And if in that situation, you're going to be subject to the one purpose test. So if you don't fit within a safe harbor, then the test is going to be, was one purpose of that remuneration that you offered or you received in order to induce or reward referrals. As you can appreciate, that's kind of a difficult standard to defend against. So you're always going to want to try to make sure that you're outside the scope of the anti-kickback statute or that you fit within a regulatory safe harbor, because what happens if you violate it? Hey, this is a felony, folks. The False Claims Act, yeah, you have to pay back a bunch of money, but under the anti-kickback statute, you go to jail. You can go to jail for up to 10 years. In addition, you can get hit up with a $100,000 criminal fine. To add insult to injury, you can also be subject, in the wake of the Affordable Care Act, to civil penalties for a violation of the anti-kickback statute of up to about $125,000. In addition, you have to pay treble damages, and it's a violation of the anti-kickback statute is automatic exclusion from Medicare or Medicaid. Now, the government has said if you do find that you've got a False Claims Act violation and you do a self-disclosure to the OIG in order to minimize your liability, the government has said that the least amount that they will accept in a self-disclosure is in an anti-kickback violation is at least $100,000. So you got to be aware of the anti-kickback statute. Let's break it down a little bit further. First, the anti-kickback statute applies to anyone who offers, receives, solicits, pays this remuneration in order to induce referrals for items or services payable by federal healthcare programs. It applies to people on both sides of the deal. Not only those who are paying it, but if you've got physicians or others who are coming to you and wanting you to, telling you that, hey, if you give me this money, then I will I will send my patients over to you. That it applies to those people who solicit that as well as the people who actually pay it. Now, importantly, the anti-kickback statute only applies to remunerations for items or services that are payable by federal healthcare programs. It's a federal statute. It only applies to federal programs that could include Medicare, Medicaid, CHIP, etc., any of those. So it only applies to Medicare or federal programs. A lot of people may, or some people may say, well, we're clever. We want to set up, pay for referrals, but we realize the anti-kickback statute's out there. So we will pay for non-federal program business, but we're not going to pay, or we will, but we'll, we will pay for non-federal program business, but we're not going to pay for federal program business. So they carve out federal programs from that, remuneration scheme. The government has said, hey, you got to be careful about that. That's not necessarily going to protect you, because if you're paying for these private pay referrals, we know that those people are probably also going to send their federal program referrals to you, and therefore you're really paying for the federal program business as well as the private pay programs. And therefore, in an advisory opinion, the government said, hey, we still reserve the right to come after you. So be careful about those carve-out programs. Now, the anti-kickback statute is incredibly broad. I already mentioned it applies to anyone, and it applies to any form of remuneration to induce or reward referrals for federal program business. It could be money. It could be contract payments that is set up. You thought that it was okay, but it's contract payments, but maybe you're paying for more than the services are really worth, or you're paying less than the services are worth, or you're paying for services that you really don't need. So it could be overpayments, underpayments, could be free or discounted items or services like perks, gifts, thank yous, professional courtesies, offering free or reduced space, equipment, meals, insurance trips, subsidies, free CME, subsidized CME, anything of value, essentially anything of value can trigger the anti-kickback statute. Could be waivers of copays or deductibles, low interest loans, business opportunities where they don't have to buy in, but they just have an opportunity to participate. Anytime you're giving anything of value in order to induce or reward referrals, and those referrals involve federal program business, you got to be concerned about the anti-kickback statute. If you're going to do any deal with a referral source for federal healthcare programs, you got to be thinking about the anti-kickback statute. Case in point, US v. Anderson. It's an oldie but a goodie. This was a situation where a clinic wanted to increase its care for certain geriatric patients. They looked around, they found a couple of physicians who had very profitable, a big portion of the geriatric business. So the clinic decided to pay those two physicians as independent contractors $75,000 a year to serve as co-directors for their medical director of the geriatric department. But what did the physicians do in exchange for that? Well, apparently very little. At least there wasn't much documentation to show that the physicians were paid fair market value for legitimate services. And as a result, the government came in and said, no, what you were really doing was just paying for their referrals. Guess what? Physician one had to go to jail for 6 years, $75,000 fine, and $142,000 in restitution. Second physician got 3 years and a $25,000 fine. The clinic CEO got 4 years and a $75,000 fine. The clinic CFO, his acquittal, was originally convicted, but his acquittal was reversed. The only good news, I suppose, is the clinic attorney got off, but even that's a little bit scary for we attorneys. The bottom line is this can apply to anybody in the office. You got to be concerned about the anti-kickback statute. So the way the analysis goes, if you're offering remuneration, which is anything of value, and you've got an intent to induce or reward referrals for items or services payable by federal healthcare programs, it is an anti-kickback violation unless you have structured the deal to fit within a regulatory safe harbor or you have obtained an advisory opinion. The anti-kickback statute has a number of safe harbors. If you structure your transaction to meet all the requirements of one of these safe harbors, then you're okay. For example, there's safe harbors that apply to certain types of bona fide employment relationships, to personal services contracts, so long as the contract has certain terms in it, space or equipment leases, investments in large or small entities, investments in your own group practice, investments in ASCs, sale of a practice, practitioner recruitment, OB malpractice subsidies, the waiver of beneficiary copays and deductibles, transportation programs, and so forth. Most recently, in 2021, the anti-kickback statute regulations were amended to include new safe harbors that apply to value-based care arrangements, care coordination arrangements, and patient engagement incentives. These aren't all the safe harbors. There's a whole bunch of safe harbors, about 40 of them, all found at 42 CFR 1001.952. Bottom line here is if you think that you have a potential anti-kickback issue, if you want to do a deal with a potential referral source, you ought to be looking at the safe harbor, an applicable safe harbor, to make sure that you can satisfy all the requirements within that safe harbor. To be safe, you must satisfy all the requirements in the safe harbor. If you don't satisfy even one of the technical requirements within each of those safe harbors, or the applicable safe harbor, it's a potential violation. Now, the closer you come, the better off you are, but you're not going to be safe unless you satisfy all of those. So the first thing you're going to want to do is look to see whether you can fit within a safe harbor. If you can't, you do have the option to go to the government and you can request an advisory opinion telling them that, hey, this is what we would like to do. If we do this, will you come after us? And the government can issue advisory opinions. Now, most of the time, you're not going to do that. But what you can do is you can go to the government's website where they've posted all of these advisory opinions. Those are available for you to search and review. And if you can find a favorable advisory opinion that where the government said, hey, it's okay under these particular facts, and if you can structure your arrangement to satisfy or align with those facts, chances are you're going to be safe. No guarantees, though, because the advisory opinions are only binding on those parties to the advisory opinion, but you're probably going to be safe if you structure it that way. In addition, in some of those advisory opinions, the government has identified factors that the government will look at in determining whether or not they're going to prosecute an anti-kickback violation. Now, these are not safe harbors, there's no guarantees, but these are some of the factors that the government would look at to evaluate risk, or you may want to look at to evaluate your risk. For example, were there fewer limited referrals arising out of this arrangement? Was there a low risk of adverse impact on the federal program? So no reason to suspect that this really did result in any abuse or fraud or waste of federal program dollars. Does this arrangement skew clinical decision making such that it's encouraging people to make the referrals to you not because it's in the patient's best interest, but because they get money out of it? Did you overall pay fair market value for the services that you were getting? Now, the government has emphasized that fair market value is not enough. Just because you pay fair market value doesn't necessarily mean that there is not an anti-kickback violation, but it's a factor. Did you give notice to the patients of this relationship so that they understood that, that this relationship was going on and therefore they could choose to go someplace else? Did you structure it so that the compensation was not based on referrals and you're not tracking the referrals arising out of the relationship? There are others that are identified throughout the advisory opinions, but those are some of the common ones. All right, that is the Anti-Kickback Statute. Its evil brother is the Eliminated Kickback and Recovery Act, or ECRA. ECRA arose out of the opioid epidemic, came out a few years ago. It's similar to the Anti-Kickback Statute, but both narrower and broader in different aspects. Under ECRA, you cannot solicit, receive, pay, or offer any remuneration in return for referring a patient to a laboratory, recovery home, or clinical treatment facility unless the arrangement fits within a statutory or regulatory exception. What happens if you violate that? Well, again, like the Anti-Kickback Statute, this is a felony. You get a $200,000 criminal fine and up to 10 years in prison. Actually, I think that's up to, I have to double check. That may be longer than that. Maybe up to 20 years in prison. But note, however, that ECRA, whereas the Anti-Kickback Statute applied to any arrangement involving federal program money, ECRA only applies to referrals for laboratory, recovery home, and clinical treatment facilities. Recovery homes and clinical treatment facilities, those are kind of SUD programs, but ECRA is actually broader and applies to any laboratory, any clinical laboratory. Now, note that ECRA, remember the Anti-Kickback Statute only applies to referrals for items or services payable by federal health care programs. ECRA applies to all payers, including private pay situations, private payers, even the patient themselves. If you're offering inducements in order to get lab services, then there is potential violation of ECRA. So any of you who are operating labs, you have to be very, very careful about ECRA, because things you could do even under the anti-kickback statute, you cannot do under ECRA. Now there are, like under the anti-kickback statute, there are certain safe harbors that apply to ECRA, but the safe harbors do not align with the anti-kickback statute. The safe harbors under ECRA are different. For example, the anti-kickback statute has a broad exception that applies to bona fide employees. ECRA has an exception, but unlike the anti-kickback statute, it prohibits you paying from compensating physician or your employees based on their referrals for lab services. The bottom line here is, again, be really, really careful in doing deals involving labs, because ECRA may apply even if you were safe under the anti-kickback statute. You may have exposure under ECRA. All right, let's talk about the Ethics in Patient Referrals Act, or more commonly known as STARC. To understand STARC, it's important to go back to the 80s and 90s. What was going on here? So back in the 80s or 90s, the government changed their reimbursement rates for physicians. They reduced the rates, and so physicians were looking for ways to supplement their income. Well, the government started recognizing, hey, we're getting more and more referrals or paying out more and more money. There's more and more claims for like lab services, imaging services. What's going on here? And they did a study and concluded that the reason that they was that physicians were out there investing in these collateral sources, these ancillary services, in order to increase their revenue stream. And so these physicians were making more referrals to these entities because they had an ownership interest and they got money for making those referrals. Well, Representative Pete Stark says, well, what do we do about that? He came up with the Stark Law. Under Stark, it says that if a physician or a member of the physician's family has a financial relationship with another entity, okay, that physician may not refer patients to that other entity for certain designated health services payable by Medicare or Medicaid, and that entity may not bill Medicare or Medicaid for any designated health services or DHS that were improperly referred, unless the arrangement was structured to fit within a regulatory safe harbor. Okay, what happens if you violate that? Well, there is no payment for the services that were provided per the improper referral. If you were paid, then you've got to repay that back to the government within 60 days. In addition, if you fail to do that, if you fail to do the repayment, then you can get hit up with civil penalties, currently about $31,000 per claim. If you're a physician, you came up with some kind of a scheme to try to circumvent Stark, then you can get hit up with penalties of about $206,000. If you've got a Stark violation, then you've almost certainly got a False Claims Act violation. Remember that case that Community had to pay $345 million arising from Stark Law violations, right? And it's also likely going to be an anti-kickback violation. So you not only have to be worried about Stark penalties, but you also have to be worried about the False Claims Act penalties and the anti-kickback violations that we talked about. Now, to understand Stark, remember, Stark does not prohibit a physician's financial relationship with another entity. It just says, hey, physician, if you do have that financial relationship, or if your family member has that financial relationship with that other entity, physician, you can't make referrals to that entity, and that entity can't bill for those referrals for certain designated health services unless you structured the deal to fit within a regulatory safe harbor. Now, remember, the anti-kickback statute applied to anybody. Stark only applies to referrals by physicians. It only applies to referrals by a physician or if the physician or a member of the physician's family has a financial relationship with that provider of designated health services. So Stark only applies to physicians or their family members. Well, who are physicians? MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors. It does not apply to APPs, does not apply to other healthcare providers other than physicians as defined here. But it also applies if there's a financial relationship with a family member of the physician. So if you're a hospital and you employ a physician's family member, then you need to make sure that you structure that employment contract to fit within a Stark safe harbor. Now, Stark is predicated on a financial relationship. If the physician or their family member has a financial relationship, then that's what limits the ability of the physician to make the referrals. Well, what are we talking about with a financial relationship? Well, it could either be a compensation arrangement or an ownership or investment arrangement. A compensation arrangement is, again, any situation where you're giving value or exchanging value, where you're providing any remuneration. It could be an employment contract, an independent contractor arrangement, leases, gifts, providing free items or services, including providing free or discounted space or practice support or subsidies, professional courtesies, loans, or giving anything else of value that can create a compensation arrangement. In addition, it applies to ownership or investment arrangements. So if the physician has an ownership interest in an entity, then that creates a financial relationship, and that physician can't make referrals to that entity unless they've structured the arrangement to fit within a regulatory safe harbor. Now, those financial relationships can either be direct or indirect. A direct relationship is where the physician or their family member has a direct financial relationship. They contract directly with the DHS entity, or the DHS entity provides the money or other remuneration directly to the physician or family member. Or it could be an indirect financial relationship where, for example, a physician or a family member owns another entity, and that other entity then contracts with the DHS entity. And that can create an indirect financial relationship that can also trigger Stark. So now remember that Stark only applies to unlike the anti-kickback statute, where it applies to the referrals for any items or services payable by federal healthcare programs. Stark only applies to referrals for certain designated health services payable by Medicare or Medicaid, including the designated health services, or DHS, or inpatient and outpatient hospital services, outpatient prescription drugs, clinical labs, physical, occupational, or speech therapy, radiology and certain imaging services, radiation therapy and services, supplies, home health services, DME and supplies, parenteral and enteral nutrients, equipment and supplies, prosthetics and orthotics. So Stark, you only have to be concerned if you've got a financial relationship with this physician, and this physician is going to be ordering or referring any of these designated health services that are up here. Now, for some of those, clinical labs, therapies, radiology and imaging, radiation therapy, the government has published a list of CPT codes that contain the applicable DHS. So if you're talking about those certain DHS, you can go to the government's website, look up at the CPT code list to see whether or not those CPT codes are covered. For the other DHS, looking at that CPT code doesn't solve the issue. You'd have to look at the definitions under the regulations. So you got to be concerned about Stark anytime you have a financial relationship between a physician or their family member, and that physician is going to be making referrals to you for designated health services that are payable by federal healthcare programs. Case in point is the Toomey case, again, an oldie but a goodie from back in 2015, where the Toomey health system had to pay $237 million because their employment contracts violated Stark. The way that it worked is the government went through and looked at it. They concluded that the government over this time period had paid $39 million, over $39 million, based on services that were ordered by these physicians who had the improper employment contracts. Under the False Claims Act, remember, they get treble damages, so you tack on treble damages on top of that for another $117 million. And then for each time that you submit a false claim, you can get hit up with additional penalties, right? The government said that there were 21,000 false claims that were submitted over the time period at $5,500. Back then it was cheap, right? It was $5,500 per claim. Then that added up to another $119 million. So it resulted in a total judgment of $237 million that Toomey was potentially obligated to pay. Now, they ultimately settled for $72 million, which is better, but it's still a lot of money, a lot of from the bottom line. The qui tam relator, the physician who brought this, or the qui tam relator who brought this action, received $18 million of that settlement. All right, so when it comes to Stark, analyzing whether it applies, remember that unlike the anti-kickback statute, intent is irrelevant under Stark. Doesn't matter whether you had good or bad intent. Under Stark, it says, what do we call a strict liability statute? You either comply or you don't comply, okay? Doesn't matter what you intended. So the test is, do you have a financial arrangement, or is there a financial arrangement with a physician or the physician's family If there is, does that physician make referrals for DHS? And then it's going to be a Stark violation unless you've structured the deal to fit within one of the regulatory safe harbors or have obtained a favorable advisory opinion. Now, there are certain safe harbors that apply to ownership and both ownership and compensation arrangements. When it comes to these safe harbors, again, it's important to recognize that you got to satisfy all the criteria under each safe harbor. Each safe harbor has a bunch of requirements, and unless you satisfy each of the requirements for that safe harbor, then the safe harbor is not going to apply. So when it comes to ownership and compensation arrangements, one of them is the physician services or in-office ancillary services. That's the one that allows group practices because, well, just so you know, Stark applies to group practices, right? Because if a physician has a financial relationship with their group practice, they're ordering stuff from the group practice. The group practice is billing that stuff. That constitutes, that triggers Stark. And so generally, you need to make sure that the physician arrangement with the group practice complies with Stark in order to satisfy. There's a couple of safe harbors that would apply, the physician services or in-office ancillary services, but in both of those cases, in order to get the benefit of the safe harbor, the physician group has to qualify as a group practice under Stark. And so you'd want to make sure that your group practice is structured to fit within the exception under 42 CFR 411.352. There are some other safe harbors that apply to both ownership and compensation. There are other safe harbors that apply to only ownership arrangements. Most importantly, the rural provider. If you're a rural provider, you've got quite a bit of protection under Stark, but you'd need to make sure that you can satisfy that rural provider exception. Most of the time, though, we're dealing with compensation arrangements. There are a bunch of Stark safe harbors that apply to just compensation arrangements. These are the safe harbors that would apply to, for example, physician employment contracts or employment contracts with physician family members, personal services contracts. There's a new one for remuneration to a physician for less than $5,000 per year. If you can structure it to fit within that, then you can fit within the safe harbor, even though you didn't satisfy the other safe harbors. There's one for fair market value, space and equipment leases, timeshare arrangements, recruitment and retention, non-monetary compensation up to, I think it's about $430 or $450 now, medical staff incidental benefits, professional courtesies, OB malpractice subsidies, isolated transactions such as the sale of a practice or settlements, payments by a physician, certain arrangements with hospitals, group practice arrangements with hospitals, blah, 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 blah. Including new ones that apply to value-based enterprise arrangements. The bottom line here is if you're doing a deal with physicians, you're going to want to structure that deal to fit within one of the Stark safe harbors. Now, if you can't fit within the safe harbor, you do have the option, like under the anti-kickback statute, to go to the government and request an advisory opinion. There aren't as many advisory opinions when it comes to Stark as there are like the anti-kickback statute, but nevertheless, the government publishes those advisory opinions on this website that may provide you with some guidance. In addition, that government's website contains some FAQs concerning Stark. This is where you go to find out the list of CPT codes that apply to certain designated health services. And this is the one that the website that has information concerning if you do have a Stark violation, how you go about doing a self-disclosure to the government. So for the Stark analysis, you have to ask yourself, is there a financial relationship with a physician or their family member? It can be a direct or indirect relationship, could be an ownership, investment, compensation, or any other payment or benefit. If there is, you've got to ask yourself, okay, does the physician refer DHS payable by Medicare or Medicaid? If it is, the lights should be going off, right? The alarm should be going off, and you got to ask yourself, does that arrangement fit within a regulatory safe harbor? You got to check the specific requirements for the safe harbor, and you've got to satisfy all the elements in the safe harbor. You know, close does not cut it when it comes to Stark compliance because it's a strict liability statute. And remember, if you don't fit within Stark, you've got an affirmative obligation to report and repay. And if you don't, you can be hit with all of those other penalties. All right, that is Stark. Let's talk about the civil monetary penalties law statutes. The civil monetary penalty law statutes, they actually cover a whole bunch of different things, including submitting false claims, violating the anti-kickback statute Stark, and so forth. But the ones I wanted to cover today are those dealing with offering inducements to program beneficiaries, offering inducements to physicians to limit services, and submitting claims for excluded entities. Let's talk about the beneficiary inducements one. This is the one that applies to your relationships with your patients who are Medicare or Medicaid beneficiaries. It generally prohibits you from offering remuneration to Medicare or Medicaid beneficiaries if you know or should know that that remuneration is likely to influence such beneficiary to order or receive services from a particular provider or supplier. This is what would prohibit you from offering freebies to your Medicare or Medicaid beneficiaries to get them to come to you to receive care. What happens if you violate it? Well, $25,000 per violation and exclusion from Medicare or Medicaid. And by the way, you're also going to have an anti-kickback violation, almost certainly. So in addition to the civil penalties, you can get hit up with the criminal penalties under the anti-kickback violation because the patient is a referral source for purposes of the anti-kickback statute. Well, what is remuneration? It only applies if you're offering remuneration, but just like under the other statutes, remuneration is anything of value, including, according to the definitions in the statutes, items or services for free or less than fair market value unless you satisfy certain conditions, and it expressly covers waivers of copays and deductibles unless you satisfy certain conditions. Now, the definition of remuneration contains certain exceptions. These operate kind of like safe harbors, that you won't violate the civil monetary penalties law if you can fit within these particular exclusions to the definition of remuneration. The first is, this actually isn't in the definition, but the government's issued some guidance. If you're offering remuneration to patients and in the form of items or services that are less than $15 per item and a total of $75 per patient per year, if you satisfy that, then they said, hey, that's a minor issue and we're not going to worry too much about that. There's also, remuneration does not include waivers of copays or deductibles based on financial need or failed collection efforts, as long as you satisfy certain criteria, among other things, that it can't be advertised in advance. The items or services, if there is a financial need and certain conditions are met, certain incentives to promote certain kinds of preventative care, but not just all preventative care. There's certain requirements that have to go along with that. If you structure your arrangement to fit within an anti-kickback safe harbor, then you're automatically safe under the civil monetary penalties law. But the reverse is not true. Just because you satisfy a CMPL exception does not mean you're protected under the anti-kickback statute. All right, so there's other safe harbors that are applicable. Just like under the others, you've got to satisfy the conditions in order to get the benefits of the exceptions. Now, just like the anti-kickback statute, you can go to the OIG and request an advisory opinion. Most of the time you won't do that, but they've published those advisory opinions. So if you're worried about a civil monetary penalties law or anti-kickback statute, you can go to the website, the government's website here, and look at the advisory opinions that have been published and see if you can structure an arrangement to satisfy a similar safe harbor. All right, that's the civil monetary penalties law. Again, that's the one that limits your marketing schemes or your marketing arrangements that you might have with Medicare or Medicaid beneficiaries. There's another one that applies to physician inducements. This one prohibits a hospital or a critical access hospital from knowingly making a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services provided by Medicare or Medicaid beneficiaries who are under the direct care of the physician. The concern here is when the government went to a prospective payment system where hospitals were paid based on the DRG, so they get X dollars for every diagnosis or for admission of a patient with a heart condition or whatever it might be. The government was concerned because they only get X dollars that they might go to their physicians and say, hey, if you help us reduce our costs so that we make more profit, then we'll share a portion of that savings with you. And that's why they came out with this statute. What are the penalties? Well, currently about $6,000 per violation, plus you can be excluded from Medicare or Medicaid. Beware those gain sharing arrangements. They can also result in violations of Stark and the anti-kickback statute. All right, the next one is the excluded entities. The civil monetary penalties law states that excluded entities that have been excluded from participating in Medicare or Medicaid, cannot order or prescribe items payable by federal health care program. In addition, if you hire or contract with an excluded entity, you cannot submit a claim for an item or ordered or furnished by an excluded entity. In addition, if you're an owner and you've been excluded, you cannot retain your ownership in an interest if that entity is going to continue to participate in Medicare. And finally, you cannot hire or contract with an excluded entity to provide items payable by federal healthcare programs. If you're excluded, you're blacklisted. That is kind of the death knell for being in the healthcare industry in these days. What happens if you violate this? Well, you can get hit up with $25,000 fine for per item or service that were improperly ordered or that you billed the government if that was ordered by an excluded entity, or if the money that came in was used to pay an employee who is excluded. You can also get hit up with treble damages, repayment of the amounts paid, and you yourself could be excluded from Medicare or Medicaid by submitting claims by an excluded entity. Well, how do you know whether the person's excluded? Well, you check the OIG's list of excluded individuals and entities on a regular basis. So you can go there and go to this website, and you should be looking at that. When you hire or credential providers, you should be checking to make sure they're not on that LEIE. If you are doing significant arrangements with independent contractors or other service providers, you should be checking the LEIE. There is no specific rule on how frequently you must check, but because if you are submitting claims when you knew or should have known that they were excluded, then you could be liable. Well, if they're published on the LEIE, then you maybe should have known. So you should be checking that on a fairly frequent basis to determine whether or not these people are excluded. All right, those were the main federal laws that I wanted to cover. Just real quickly, those aren't all of them. There are also a bunch of federal criminal statutes, but usually the government uses those others to go after you. In addition to the federal statutes, as I mentioned, you've got to be concerned about state laws because each state may have their own fraud and abuse laws. Now, a lot of them, almost all of them, will have laws that are similar to the federal anti-kickback statute. Some of those, most of those will be limited to, Medicaid programs, government payment programs, but sometimes they can extend to even private pay situations. You may have your own mini Stark laws that have self-referral prohibitions. Most states, licensure acts particularly, will have fee splitting prohibitions that prohibit licensed individuals from splitting fees or sharing fees in order to get referrals. They may have laws that require disclosures of financial interests. There may be insurance statutes, Medicaid conditions, fraud or misrepresentation claims, consumer protection laws, bribery claims. There's a whole bunch of potential laws out there, so you need to know the laws in the state in which you're engaging in business to make sure that they would allow the services that you're going to want to do. The penalties can range anywhere, sometimes civil penalties, sometimes criminal penalties, maybe adverse licensure actions, so you could lose your license if you engage in this improper conduct. Just remember that whereas most of the time the federal statutes only apply to government programs, except for ECRA, the state laws may be broader than that and may apply to private pay situations. You may also have to be concerned about private payer concerns because you may be violating the contract. So you may be subject to, if you violate the terms of your contract, the private payer can sue you for breach of contract, but they also might try to assert some kind of state law claim, maybe under some kind of private cause of action, something like an unfair business or unfair trade practices claim or the like. So make sure you're aware of your obligations to private payers also. All right, that's a quick summary of the relevant fraud and abuse laws. So what do you need to do about that? Well, I think if you haven't done so recently, you'd ought to go back and look at your relationships, right? Your relationships, your practices, your marketing schemes with your patients. Look at your billing policies. Are you waiving copays or deductibles that could violate the anti-kickback statute? Are you doing it write-offs or prompt pay or self-pay discounts, free or discounted items or services? If you are doing those, have they been structured in order to fit within a safe harbor or an advisory opinion? What about your marketing gimmicks? Are you offering thank you gifts with your patients or loss leaders or referrals, refer a friend program situations where you're offering gifts if they'll refer a friend? Are you offering free screening programs, things like that? There's ways that you can do that with relatively minor risk, but you need to make sure that they're structured appropriately. What about arrangements with other referral sources like other providers? or your employees are independent contractors. You have to look at your contracts generally to make sure that they're fair market value, the compensation is not based on referrals, and that they're for services you're paying fair market value for services that were actually needed and provided. Again, you're going to want to look at the Stark and the anti-kickback statute safe harbors to ensure that you can fit within those. Look at your arrangements with visiting specialists. Overpayments or payment for items that were not provided, gain sharing arrangements, joint ventures, practice support, professional courtesies. Anytime you've got anything of value with a referral source, you need to make sure that it's structured appropriately to fit within the regulatory safe harbors. You probably ought to go back and look at it and ensure that you've got an updated compliance plan. In November, the government updated its general compliance plan, including the elements that they would like to see in an effective compliance plan. An effective compliance plan is important for two reasons. One is it might help ensure that you actually remain compliant. Two, if you do fall out of compliance, if you have an effective compliance plan, theoretically, the government will go easier on you. On the other hand, if you don't have a compliance plan, or if you're not following your compliance plan, then that could look bad for you. In order to have an effective compliance plan, the government has suggested that your compliance program ought to have written policies and procedures concerning the laws we talked about today, compliance leadership and oversight, so you have the right people in place, compliance officer or others who can make sure that the compliance plan is working. Educate and train your employees concerning their obligations, maintain effective lines of communication with the compliance officer, and a disclosure program like a hotline or something else that would allow people to report potential problems and not be retaliated against. You want to document that you're enforcing those standards, including consequences and incentives to ensure compliance. You should have some kind of ongoing risk assessment, auditing, and monitoring program to make sure that you're not in violation. And if you do have a problem, you've got to respond appropriately to any detected offenses. You're going to want to train your key personnel, including obviously your administration, but your compliance officers and committees, human resources personnel, particularly when it comes to paying physicians and others, physician relations and medical staff officers, marketing and public relations, because what you can do in other industries, you cannot do in the healthcare industry, and people in your marketing department may not understand that. So you may need to teach them those things. Your governing board members, purchasing, accounts payable, all of those need to understand so that they can identify potential risk areas or red flags. You're going to want to document the training to show that you acted in good faith. And, once is not enough. You need to review and repeat that on a periodic basis. If you think you have a problem, then don't continue doing the problem, right? Don't continue doing it. It's one thing to submit a claim when you didn't know that there was a problem. It's another thing to submit it when you do know that it's a problem. One is a clear violation of the False Claims Act. The other one, if you didn't know and you report and repay it, then it doesn't turn into a False Claims Act. So if you think you have a problem, then suspend that process while you work it out, while you determine it. Investigate your problem per your compliance plan. You may consider involving an attorney to maintain the attorney-client privilege concerning your investigation. You should implement an appropriate corrective action, which could include sanctions against employees. But remember, just correcting it going forward is not enough, because under the False Claims Act, you generally have an obligation to report and repay if you've made violations. So just prospective compliance is not enough. If there is a repayment due, then you need to make sure that you repay that per the applicable law. The government has different repayment processes that we're actually going to cover in a webinar in a couple of weeks. That we'll be sending out more information about that. All right, that is it. That is a very quick summary and a review of the key federal fraud and abuse laws. If you have any questions, feel free to shoot me a quick email. I'll do my best to respond. If you need additional resources, you can go to the government's website, which has a bunch of compliance stuff. As I mentioned, the new compliance guidance that the government just issued is very helpful and has a really good summary of the things that we've talked about today so that you can take it back to your staff and use that for training. Also, I have a bunch of content on our website that's all free, including webinars that we've recorded, client alerts, white papers on these and other topics that you can always access. There it is. Thank you very much. Appreciate your participation today, and I hope you're doing well. And I suppose this was appropriate for Halloween, but hopefully you're not too scared by the things we talked about today. I wish you the well.